I welcome you to this section on recent developments of sale and purchase agreements of companies in Europe. My name is Thomas Meyding. I'm a partner of CMS Hase based in Germany. I head the corporate group of CMS. If we look at the share purchase agreements or so-called SPAs, we can see a trend to a standardization. Certain clauses are contained in almost every SPA. What are such key clauses? First of all, what is going to be sold? Shares or assets? This needs to be contained in the agreement. Purchase price and any adjustment mechanism. Conditions to closing. Conditions to closing have an impact on deal certainty. There are certain conditions to closing which are mandatory by law, for example, cartel approval. There are other deal conditions to closing which parties agree on. I will speak later on one of such conditions closing. Representation and warranties. I would say in almost no SPAs, parties relied on the legal framework provided for by the respective jurisdiction, but agreed on a distinct set of representations and warranties. These are lengthy discussions in which parties try to agree on a description on certain events relating to the business. Secondly, the remedies again are stipulated in the SPA. Parties do not rely on the legal framework, and in particular carve-out of liabilities are contained in the agreement. Taxes have a separate life in the agreement. They are a distinct set of clauses in the agreement, quite often a separate scheme, and sometimes even in an appendix as a separate tax agreement. Lastly, non-compete, non-solicitation in order to protect the target business against the seller. We have analyzed within CMS now for over 6 years transactions CMS has been involved in. These are privately negotiated transactions, 2,000 transactions over the last 6 years. The survey allows us to analyze time trends in M&A deal points. If we recall, the period covers the Lehman crisis and the impact on M&A transactions and on M&A deal points. It allows to draw comparisons between European regions. It allows to compare European market practice with US market practice. If we refer to the US market practice, we rely on a study published by the American Bar Association. It's the so-called 2013 Private Target Mergers and Acquisitions Deal Point Study. I would briefly focus on the regional split. If you see the regional split, so you see approximately 35% of the transactions have been conducted in the German-speaking area of Europe, 17% in CEE, and approximately 22% in the UK. This is somewhat representative for the deal activity in 2013. I would like to focus now on 6 deal points relating to the clauses I mentioned at the beginning, and I would like to start with the purchase price. We see a development in Europe that purchase price adjustment mechanisms are in the decline, or fixed purchase prices have been increased over the last years. More than 50% of the transactions contained a fixed purchase price. This is a different development to the development in the US, where more than 85% of the transactions contained a purchase price adjustment mechanism. What are the criteria for such purchase price adjustment? Mostly financial data, financial figures, mostly based on statements prepared as of closing, i.e. on execution of the transaction. And this has to do with the method of evaluation. The enterprise value of a company is calculated without taking into account cash and debt of the target company or the target group. Hence, cash is added, any debts are deducted, and such words need to be defined very carefully in the SPA and needs to be defined looking at previous financial statements. If we look at another adjustment criteria, working capital, we see a trend in Europe that they are more often used, but still not as often as in the US. In the US, more than 90% of the transactions contained such a working capital adjustment clause, whereas in Europe it's still only 40%. Another criteria or another deal point are earnouts. Earnouts, or the importance of earnout clauses, are not reflected in the number of transactions which actually had in the end an earnout clause. Only 14% of all transactions contain such an earnout clause, and this has been consistent over the last 3 years. Different trend in the US. In the US, significant higher percentage contained such an earnout clause. An earnout clause is a way to bridge differences in the price expectations, the price the seller would like to have, and the price the purchaser is prepared to pay. And if you are in competitive auction process, you may propose an earnout. But if we look at the criteria used for the earnout calculation, quite often, and in particular in Europe, EBIT or EBITDA are the criteria in order to calculate this earnout. And if we look at the financial figure EBIT or EBITDA, there's quite some wording necessary in order to protect the seller against manipulation of the buyer in order to reduce or to artificially influence the earnout calculation. The US relied more often on turnover-based criteria, hence this is somewhat easier, and this may be a reason why it's more often used in the US. If we turn from purchase price to the reps and warranties, i.e. basically exposure of the seller for what he's going to be sold, there are different ways in order to reduce such exposure. One is that all claims need to exceed a certain threshold or basket in order to qualify as a claim under the SPA. In Europe as well as the USA, more than 50% of the agreements contained baskets, but we see a different practice in US and in Europe with respect to the question whether, if such benchmark is exceeded, the buyer is able to claim the first euro or only the excess beyond the threshold. If we look at the percentage of purchase price which are agreed on to define the benchmark, we see a different practice in US and Europe. In Europe, 50% of the baskets or thresholds exceeded 1% of the purchase price, whereas in the US, more than approximately 56%, more than 50%, amounted only to 0.5% of the purchase price. This has to do with another option to reduce the exposure, de minimis. In Europe, quite often the agreements contain an additional element of risk mitigation, and this is that a claim is only eligible for a claim for breach of representation and warranties if such claim exceeded a certain minimum amount, and more than 50% of the agreements in Europe containing such a de minimis clause amounted to a threshold or de minimis of 0.5 up to 0.5% of the purchase price. I mentioned de minimis, I mentioned threshold basket. Lastly, the question is, to what extent is the total purchase price at risk if a seller sells his business? And if you look at the slide, you see certain percentages, and these percentages only relate to so-called normal operational warranties. Quite often different percentages or caps are negotiated for any claims with respect to taxes, for environmental issues, and for claims if the seller does not own what he wants to sell, i.e. title. If you look at the caps for normal operational warranties and representations, we see that in the US quite often the cap is up to 25%. 87% of all transactions in the US contained a cap of up to 25%, whereas in Europe 53% of the transactions contained a cap in excess of 50% of the purchase price. Coming to next set of deal points, and I mentioned at the beginning closing conditions. MEC is one of the closing conditions, quite often used in the US. 94% of all transactions contained such a MEC clause, whereas in Europe it's only 14%. There are a lot of reasons why this is the case. What does a material adverse change actually mean? The MEC clause is supposed to protect the buyer against material adverse changes between signing and closing, i.e. execution of the transaction. There's obviously a conflict of interest, and in Europe sellers are very keen to have deal certainty or to have an obligation on the buyer to close if the agreement is signed. This may be one of the reasons why the MEC clause is not so commonly used in Europe. If once you have agreed what a material adverse change actually constitutes, the second round of discussions start with respect to carve-outs, i.e. exclusions from the MEC, and this is a general economic downturn, force majeure, or unforeseeable economic developments within the target. Another deal point which is quite often discussed and which I believe is a very interesting one to show regional differences within Europe is the question whether the parties agree on state court proceedings or on arbitration proceedings. You see that approximately 37% of the transactions contained an arbitration, provided for arbitration as the dispute resolution mechanism. But if you look at the various regions, you see that in Southern Europe and CEE, approximately 3/4 of all transactions contained such an arbitration clause, whereas in the UK and in France, parties relied on the state court proceedings. This have been 6 deal points out of many, many deal points we've analyzed. I do hope that this session was of interest to you, and I do wish you all the best for your M&A activities in the future. Thank you very much.